Hi everyone, it's Grant Abbott speaking, and I can tell you I've been looking forward to this for probably 25 years. It was years and years ago that I started looking at superannuation and also property development. When I first started at KPMG as a tax consultant coming straight out of law school into the tax field. Before that I was actually with Touche Ross, and then ended up at KPMG after a bit of a stint at the Taxation Institute of Australia, where I was the research director there. But certainly came back full swing and went into the funds management area of KPMG. We're all set up as specialists and had a lot of involvement in superannuation, a lot of involvement with funds management. In fact, did the whole of the redevelopment of Circular Quay into residential properties, or residential townhouses. So I was right in a pretty good position from day dot to know all about properties. Now, when SMSFs came about in 1994, it was a small, in fact, I did the first ever video in 1995 on self-managed super funds. And for those around those days, we used to have unit trusts that were 100% owned by SMSFs. You could borrow, you could do whatever you want. And effectively they weren't related trusts. So a lot of people would buy, in fact, they would actually buy property and let their kids live in them and live in those properties in those stage. But that was through the unit trust rather than directly, which obviously would have been a breach of the in-house assets test, sole purpose test, and generally probably Section 65, giving a financial advantage to a member or a relative. But in 1999, in fact, in May budget 1998, those related trusts where a SMSF holds more than, and this is the key, more than 50% of the underlying capital of the unit trust, or if we're looking at shares, the underlying shares, or is the ability to control the voting power, they're classified as related trusts. And of course, then they would be in-house assets, and we're caught up in those in-house asset rules. But, since that day, each year, SMSFs get bigger and bigger, and particularly with all the COVID-19 crisis, for me, it's like I'm just sitting back here. I'm feeling like the king of the castle at the moment, because I see all the large industry funds who've been smashing us and telling us how bad we are and we have too much cash, and we've really got poor returns compared to them. Being hit with a double whammy, because they're now, and congratulations to Morrison and Frydenberg. I don't even know what they did, but they certainly set the cat amongst the pigeons by allowing people to take out 10,000 now and 10,000 in July, which obviously those redemptions then have a cyclical impact, because they then impact the stock market, and it just keeps on going down and down. So it means for the next, probably 5 to 10 years, SMSFs will be big in the area of people who are 30 years and over. So we've got some exciting times are coming with self-managed super funds, but obviously property is the main game for many Australians. And while we've still got LRBAs, we've got Morrison in play, then we're in a pretty good position. But notwithstanding that, property development will always be a fact of life in Australia. And again, going back to where we were with COVID, I would have thought that having a look at all the Northern Hemisphere versus the Southern Hemisphere, particularly Australia and New Zealand, that we've done extremely well. And as a consequence of that, there'll be more and more what I call upper level migration wanting to come out here in Australia, which means more and more property development down the track. Now, we might be in a recession or even a depression for a few years, but that also means all those ridiculous development sites and prices that the Chinese were buying up, 4, 5, 6 years ago, are now out the window. So you're going to be buying. In fact, you could buy property development prices really cheaply at this present point in time. And we're working with a couple of guys. Hopefully, they're on the call. Good mates John and Clem, who are looking at buying some developments, and we're helping them buy some developments up here in Maroochydore, which I think is an absolute cracker for development going down the track. It'll take a little while to get things off and running, but they've got a good rental yields coming through there, so you can sit and patiently wait. And at the end of the day, if we have a look around all Australia, where is most of the capital? So the industry funds are stuffed. I mean, if you even saw the the industry super trusts in the property section, have actually stopped the industry super funds, or the main funds like Hostplus and that, trying to redeem their units, which I think is an interesting one to get some cash. So it's funny to see all of them eating themselves at the moment. From that perspective, is SMSF still have got $700 billion sitting in them. Of course, there's going to be some confinement around the commercial property area, but a lot of that is generally, I mean, the quickest small scale stuff for a lot of us is we've got a business real property sitting in SMSF and it's being leased back. Now, of course, you can go onto our site like your docs and get a rental reduction agreement if you want to do a renegotiated commercial lease agreement. It's not a bad idea actually in the long run, although it then goes counter to what we're seeking to do, is to push profits from a tax-paying entity such as a trust under market value rent. Obviously, we don't want to breach any of the SIS Act or be treated as non-arm's length income into our self-managed super fund, where it's taxed at a maximum 15. But if it's just a pension fund, then there is no tax. So it's a pretty good position. But going down the track, you're going to see a lot more smaller and smaller. I should say smaller developments in the self-managed super fund. But I know Tony and I have worked on the last few years more than $1 billion in transactions involving self-managed superannuation funds. And some of them are quite staggering actually to have a look at them. So you can go, property development could be anywhere. I look, even if you're just going to buy a property, a residential property, renovate and flip it, which you can do under LRBA as long as you don't change fundamentally the structure and turn like for example, a house into 2 or 3 townhouses. But if you're just going in, you've got an apartment, fixing up, doing it off, then you can do all of that under an LRBA. So that's at the really bottom end of the scale of property development. But that's going to be exciting for the new entrants into the marketplace, as opposed to like the really big enchilada deal where you're doing like 300 to 400 developments through a JV, a appropriate JV with independent partners. But look, they all have their have their to's and froms and pros and cons. We have had some recent Ato Guidelines which were released in March this year. I sent those out a while ago to our advisory base, and really it's only just been picked up by the I call them mainstream SMSF media. But I dare say that it's probably just most of it's gone straight over the top of their head, because they're the typical. Well, I'll show you what they're all focused in on at the moment. But I would say that a lot of lawyers, particularly in the SMSF space, will be running back into their shells because of this one Marcellus decision. Now, there's a lot of traps and catches, but I'm going to show you as many hacks as we can get. Bradley, just while I'm here, this is being recorded. Oh, sorry, Bradley, I should have said before. Thank you for reminding me. This is being recorded, so you get the recording, you'll get the slides. I'm going to send you the links to the Commissioner's ruling. There's another really good case studies I've found out in relation to suits, which I'll talk about a little bit later on. I'll also give you an invitation next Tuesday at 10 a.m. I'm doing a launch for our LY Protect, which is our wills product. Well, not our wills product, our whole estate planning suite, which for any of you involved in this, it's worthwhile, because you can't go down the process of building these sort of things, particularly if you're doing between 2 or 3 parties, without looking buy, sells, and more importantly, doing unit holder, shareholder agreements, and then covering what happens, death, disability, and divorce. So really we need to do a full structure. Again, you can come in around the edges, and I want to give you all the tools to show you how to do a property development really cheaply, but it's all the add-ons, the bells and whistles, the protections that really make a big difference for you. So I want to give you as much as I can, and just remember, at any point in time, you can always come back to me and ask me questions at grant at, in fact, it's grant.abbott@abbottmorley.com.au, or just grant at ilovesmsf.com, which is a lot easier. Okay, so this is one from Paul Gerard. Oh, thanks, Paul. It's great to see you on. New South Wales, I saw this as fantastic. Finally, and look, this is the best thing out of everything, COVID, is getting them to think about payroll tax and stamp duties, the states. Now, I'll tell you what, here's the first thing. They're not going to give up stamp duties and payroll tax without an increase in GST. So it's a buttering up process, and I can guarantee you within the next 3 or 4 years, we'll end up with a 15% GST. I'm not sure about they'll broaden the base to food, but I very much doubt it. And certainly they should probably take GST off dining at the moment, at least for a couple of years, while cafes and restaurants try to get back. But New South Wales is discussing a stamp duty concession where a buyer could choose annual smaller duty charges versus upfront lump sum we're used to. Now that's a really good thing, Paul, if we can get those sort of things up and running. And look, there's going to be a lot of first home buyer. I did a session on the rental reduction, the accessing the $20,000 between now and September under the generally from the industry or retail funds, or in some instances from SMSFs as well. But primarily for a couple who are in their 30s, a lot of them are thinking, well, I don't want to do that because I've been hoodwinked, I've got to have that for my retirement. Well, if you ask me, it's silly. Pull that money out, because that money can act as a pretty good leverage tool to get into your first home, or alternatively, particularly when prices are down, upgrading your home. So pull that money out, because you don't get a gift of $40,000 now, particularly if you're 40, you're not going to be able to touch it for 30 years anyway. But look, as I said, I would love to, and I'll probably watch out in the next probably week. I'll be sending out information on a property masterclass. I'd like to do a full day session online, which will be streamed, and I'll have like some of the best property people in Australia from a strategy perspective. You guys are developers, so you know that side of things, but certainly around the structuring and all of that, so that you can really move ahead. Look, again, Abbott-Family, we're there for you at each and every point in time. But again, there's a lot of stuff that you can do yourself to make, and we're not expensive in terms of legal fees, but make things a lot more efficient, because once you do one, you can do two, you can do three. So the recent ruling was actually it's a regulatory bulletin, so it's not a definitive guideline. All it says is, look, we're thinking about these things. These are the issues that we're concerned about. And look, all the stuff that he talks about, I never do anyway, so it's not an issue. But it's really important to have a good look at that, and we hopefully we'll get a bit of time today just to go over. I've earmarked some up. I'll send you through my PDF, which is all marked up for the key areas, so you can have a look. I really want you guys to be on top of this, and anyone who's in property development, this is going to be for me, estate planning, asset protection and succession is number one. SMSFs and property development are number two. So either way, if you're with I Love SMSF and like your docs, you're going to be well and truly looked after over the next few years, because that's where we're going to really focus a lot of our attention. Anyway, this is paragraph 3 and paragraph 4 of that guideline. And this is not me, this is the Commission of Taxation. Property development can, and I haven't changed this is straight off the guideline. Property development can be a legitimate investment for SMSFs. Thumbs up on that one, mate. And the Commissioner does not have any concern with SMSFs investing in property development where it complies with the SIS Act and SIS regulations. And I also put in there, you've got to be wary of the non-arm's length income rules, or as we professionals shorten it, as we like to do, the gnarly income rules in section 295-550 of the Income Tax Assessment Act 97, which if your income from a particular development is seen to be gnarly, it's taxed at 45% inside an SMSF, which then blows up the underlying foundations of why you use. Well, actually, it shouldn't say that generally the underlying foundation of why you use a self-managed super fund in the first place is, it used to be low taxation, but then again, if we're moving down the scale to the younger generation, it's locked away for a long, long time. So, the concession should be traded off with the long-term nature of the investment, which is good if you're doing property development or certainly buy and holds. But more importantly, that's where the capital seems to be at this present point in time, with the average size fund of $1.2 million. So that seems to me that's one area where we're moving into SMSFs. However, Commissioner goes on, these types of investments can cause concerns where they are used to inappropriately divert income into the superannuation environment, or if SMSF assets are used to fund property development ventures in a manner that is inappropriate for and sometimes detrimental to retirement purposes. So he does there's a case study that I'll show you a little bit later on, but I don't want to really go into it, but where you do a JV between a family trust and a self-managed super fund, the SMSF commits the property, the discretionary trust commits the cashola for the development. Everything's done by the book, and it ends up being that the discretionary trust puts in 75% of the capital, the SMSF puts in 25%, and then they do a 50-50% JV split. Now, by any stretch of the imagination, this is not a trap, it's not a trick, it's just common sense that typically with any JV, which is based on a partnership structure at common law, is you need to go in, and we've got partnership agreements sitting up on the like your docs website, but you go in, if I put in $1 million, you put in $1 million, we both expect to get 50% each. Not that because I'm a concessionally taxed person, I would get 90% of it or 75%. So that's where we've got to be really careful when we talk about streaming as well. Detrimental retirement purposes, that would be, for example, particularly the sole purpose test. We set it up to, for example, if we're a development company, to get a lot of development fees out of our SMSF into our development company, because even though they're part of our group, they are quite separate instances. Now, this is a case, in fact, it's the first case, and it's just recently come on Court of Appeal, which is getting all the lawyers knickers in a knot. So expect to see, not from Abbott-Family, and I can tell you Tony would say that, is that, we don't disclaim anything. When we give a letter of advice, you get a letter of advice, this is what you do, this is what you've got to watch out for, go down that track. Whereas you'll see a lot of other firms will give you a letter of advice, you may be able to do this, you may be able to do that, and then they disclaim everything. So it's pretty useless. And particularly now after this Marcella case, I've got to be really careful. This involved it's an estate planning, but it just as equally applies to property development or any transaction dealing with a self-managed superannuation fund. What happened here is the trustee of the fund was made a decision in relation to the distribution of death benefits, where there was no real binding death benefit nomination, and they effectively just paid the money out to themselves rather than putting it into the estate or splitting it amongst other dependents. Now, the court, the Justice Macmillan in the first instance, which was then upheld by the Victorian Court of Appeal, basically said, and this is just one out of a quite a lengthy case statement, basically said that, or actually to say judicial decisions probably a bit better, the ill-informed arbitrariness with which the first defendant approached her duties also amounts to bad faith. Now, this is interesting. The dismissive tenor of the correspondence from Hill Legal, the willingness to proceed with the appointment and distribution in the context of uncertainties and significant conflicts, and the Court of Appeal made this quite an emphatic decision as well, and the lack of specialist advice, despite the recommendation of Mr. Hayes, who was the accountant, all support the conclusions that her conduct was beyond mere carelessness or honest blundering. This conclusion is reached without reference to the lack of evidence deposed by the defendants personally, because they actually didn't get up and give evidence in the case, which was quite interesting. But the main thing, the Court of Appeal also talked about the fact that they did have a legal firm, but at the end of the day, it wasn't a specialist SMSF legal firm, and certainly not a property specialist. So out of this one, I think you've really got to just be careful about how far you take it and where your role stops and where a good lawyer's role takes on. The best thing about it, of course, if you're having discussions, you can open a file with us, at least it's protected by professional legal privilege. Okay, so this is what you need to do. So if you want to make it a really good job, you need to know your structures. So we're going to go through each of these very shortly. You need to know the law. You need to know your risks and also your limits. You need to know what the ATO is looking for. I showed you those first two paragraphs. We're going to get into a bit further. You need to know your Corporations Act, particularly if you're the developer yourself, or more importantly, if you're the accountant or planner advising to the clients about what's required in terms of getting investors on board. Where do you fit, where don't you fit? You need to know your financier really well. What are they going to give you? Where is it all going to fit in? More importantly, the big one for us is where are the charges, the mortgages, caveats, personal guarantees, where are they all going to fall? Essentially, we want to make sure that the SMSF, we want to de-risk the SMSF, but we don't want to de-risk it too much such that it falls outside. Otherwise, the commissioner may have an issue. If we went back to this Marcella case, what happened there is they actually booted out the trustee of the fund and put in place, well, I don't know what they're putting in place because it's only just been heard a couple of weeks ago, but effectively they'll put in their own trustee, or put in an independent and arbitrary trustee. I don't know how that works with SMSFs, which I sort of commented on the case. But the commissioner at any point in time also has the power to remove trustees, and has done quite a bit in the last year. So we've just got to be very careful. It's nice to go through all of this process, and it's very, very unlikely the commissioner is going to make a fund non-complying these days. He's got his instant penalties for in-house assets, breach of Section 67, breach of Section 109. So he's got these instant penalties. But his big one is if it's a really a recalcitrant trustee, what he's going to use is obviously the ability to remove the trustee, which he does on quite often. If you go and have a look at the regular compliance issues published for SMSFs by the commissioner. So you've got to know your corporations, know your financier. That's a bit of an issue there, and really got to build from the ground up. So again, the deeds we have a look at. I mean, some of you guys are paying a lot of money for deeds that are absolute crap, with all due respect. I mean, they're old. I had a look at one yesterday that was, old. It was a modern deed, or it was only set up probably a few weeks ago, the actual SMSF. But honestly, the deed looked as though it was probably 20 or 30 years old and has been patched up along the way. And again, I had a look at the website of the legal firm that completed it. They're only a small legal firm. They're not specialists in SMSF. So, they didn't write it. They've gone and bought it as a precedent from someone else, which is, I shouldn't say it's a scam for lawyers, but essentially you'll find that most lawyers don't write the documents they do. They go and buy it from LexisNexis. They'll buy it from someone else, and then they'll use that under a licensing regime, which is okay, but it means that fundamentally the documents are pretty weak. So when you build this, if your clients have got existing SMSFs, you need to start with the ground up, build the foundation. Probably there you've got two choices: do a straight SMSF, and also make sure you've got a corporate trustee. For me, I'd probably use we call our leading member, or bloodline or lineage SMSFs. It's not only is it good for asset protection, but it limits any monies going outside of the bloodline. And so I'd be upgrading that, or just simply the basic SMSF. Obviously, you're going to have to upgrade your investment strategy, and honestly, ours is second to none. Absolutely second to none. If you're using a unit trust, you want to not use a normal unit trust. You want to use a superannuation unrelated investment trust that you'll find on our site. And I'll talk about that a little bit later on, because it's got some really good bells, whistles and hacks inside it that really make sure that it's kept within those tight lanes of the SIS Act. As I said, the investment strategy is the whole caboodle. If it's a JV, you want to make sure you do that. If it's a suit, again, unit holders agreements, you want to have a look at. If it's a company, go on, so on and so forth. So you need to have a knowledge of each of those. We're going to look through. We're going to have a look through each one of those. So the four basic structures, you can see this in SMSFRB 2020/1, which I'll have a quick look at in a second. The SMSF can go directly and do the underlying property. So I'll go through and then we'll have a quick look and I'll show you how I rip through things. So SMSF directly, but the problem is if it's doing directly, it can't borrow, so it has to fund everything itself. And so, do you have enough money to do that? So for the fix up and flip or the reno and flip, you could probably do that with an LRBA in place. But if it's just a basic reno, so it's an improvement, but it's not a brand new one, and those improvements obviously can't be funded with borrowed money. They have to be funded out of the SMSF. Then you can do that through the SMSF directly, but there's only so much you can do. There's only so much money there. With the business, absolutely. So we'll have a look at whether an SMSF can run a business. One of the ones though is the best thing about an SMSF is it's a vehicle which to me is one of the top ones in terms of asset protection. It's even better than a discretionary trust in the long run. The reason that is that even when you're retired, you take money out as a lump sum. I could take out $500,000 a lump sum, and my trustee in bankruptcy can't touch that. Whereas if I'm a discretionary trust, obviously I'm just in that income play. If I take out a lot more distribution or capital out of their trust, then it goes to my creditors. So it's a really good vehicle, but we have to weigh that off. If I'm doing all the development, and we'll know, for those of you who've done developments, it's a cycle. With property development, you either win big or you lose big. So there's nothing that is sort of in between with that. So we've got to be really careful that if we take too much risk on inside the SMSF, that we can get burnt. And I want to come back to that risk element later on. We can do an SMSF JV with a family trust bucket company, related entity. And the issue about that is we've got to make sure it is a proper partnership. We've just got to be very careful. But again, my preference is for the SMSF to hold the property rather than the other way around, for the discretionary trust to hold the property and then the SMSF contribute the capital. It's not a bad way to do that, mainly because if there is a borrowing to be done at that family trust or discretionary trust level, as opposed to the self-managed super fund, where you're obviously going to be limited. You can't do an LRBA and develop a property completely, because otherwise you've got a brand new asset, replacement asset, and that would breach the LRBA rules. SIS regulation 1322C, company or trust. Essentially, that's pretty limited, and I'm not sure. I know the Commissioner spends a lot of time in 2020/1 on it, but look, I've never really seen any developments. Well, I've never recommended, except if it's in a last-ditch circumstance. But if it's a 1322C, you would use that with a JV, with a dev company, usually. But again, it's only in a last-ditch circumstance. So it's surprising that the Commissioner has spent a lot of time, and it actually surprises me saying that they've seen a lot of them come through, because essentially a 1322C company or trust, what that does, that's a wholly owned or more than 50% owned superannuation trust, a related trust. But if you seem to be involved in business, then that 1322C drops off, and then suddenly it's an in-house asset, which you then have to actually then start to get rid of or wind down your underlying investment above the 5%. And there's a whole set of rules around that, which is in 2020/1. But if you've got that issue, you can always come to us. I like personally if you're going to do a development, you might as well go big. Some of your clients have, you know what they're like. They want to do everything themselves. So, you'll be in that first three. But look, if you're going to do a development, may as well go big. Get at least 2, 3, 4 or 5 of you, and then go in and do the development properly. Of course, you're going to have to make sure you get a really good SUIT, which is the acronym for Superannuation Unrelated Investment Trust. You also need to have a really good unit holders agreement, and be very careful of that 50% rule from the ground up is really important. I'll just jump out of here. I'll bounce out of here while I'm going, and we'll have a look at the Ato guideline. In fact, here's a good mate, Trevor Ricard, who sent me a bit of a letter on SMSFRB 2020/1, which I agree. So if you're there, my friend Trev, you've done a good job, as is usual. So this is the guideline. I will send it through to you. And I'll send it through as my PDF, just so you can get the markup, because there's a lot of stuff in there. There's a lot of pages. So the main thing to do is just get the highlight. And you can see, guess where that came from? That came straight from us. So let's go through. If you're considering developing property within your SMSF or investing in a related property development entity or venture, we strongly encourage you to seek independent professional advice. In some cases, you may also wish to approach us for advice before doing so. The problem about that is, we all know, when you're doing property or property development, it all has to be done yesterday. So there's going to be a lot of time, and the Commission just doesn't do determinations or private binding rulings anymore. So you probably just need to, again, bear in mind, Marcellus, get yourself a specialist in that regard. So what are our concerns? And I'll just go through. There are no specific prohibitions preventing an SMSF investing directly or indirectly in property development. However, where an SMSF seeks to undertake investments of this nature, care needs to be taken to ensure there are no breaches of the CISA. So regulatory concerns that can arise in some arrangements include whether the arrangement amounts the SMSF being maintained for a purpose outside those permitted by the sole purpose test, which is essentially there for retirement or essentially death benefits. So as I said before, if you're doing a development and then you transfer one of the developments at a discounted price to your children, then effectively there's a breach of the sole purpose test. And so obviously we've just got to be careful about our overarching decision making in that whole process. Secondly, whether the SMSF continues to meet the relevant operating standards, including record keeping requirements, ensuring assets appropriately valued, recorded market value, and keeping SMSF assets separate from members' assets. So this is pretty typical, but where you're going through this property development, even if you go past that property development and continue to retain some in the SMSF, what we need to do from that perspective is we need to make sure that it's not set and forget. We're always continuously going over the top in terms of compliance. A lot of the issues that the Commission can pick up on is when there's no JV agreement or there's no arrangement as to what's going to happen. So we need to be really tight from the ground up, do a bit of planning now, and then set stages in it. So stage one is the acquisition of the property, building your SMSFs, again, getting investment strategy right, putting into a suit, getting your finance right. And then the second stage is then, well, okay, we're going to the market, we're looking for investors. Let's go and have a look at, from the Corps Act, how we're then going to structure it from that perspective. And then the final one is, if you're in a suit, you're not in there for a long term, there needs to be an exit strategy. So there's that three-phase requirement. We want to go down that track. Whether the arrangement includes a provision of a loan or financial assistance to a member or their relative. Again, that case I just talked about, remember we do a development and then we sell at a discounted rate to our children. One is, again, that's a Section 65 issue, which is this third point. But again, there's a breach of the sole purpose test as well, Section 62. Whether an arrangement includes the SMSF acquiring assets from a related party. So that's not a bad thing. So I'll just give you a bit of a heads up on that one. For example, if we've got traditional development, you've got a developer who holds stock or land, that may well be, when we go and have a look at the Commissioner's ruling on business real property, which I think is 2010/1, when we have a look at that particular ruling or that guideline, if we're in the business of land development or property development, that stock we have on hand effectively is business real property, which can be transferred into a self-managed super fund. So it's not a bad idea that if we're going through this process, particularly if we're in states where we can transfer property into self-managed super under a concessional tax environment, for example, in New South Wales for $500, South Australia in certain instances, if it's commercial property, is stamp duty free. Again, go back to what was said before, I think, Paul, with issue around potential concessions or stamp duty issues that may come out of New South Wales from COVID. Western Australia, there's also concessional duties there. So if we have a look through that process, it may be we can actually work out where's the best place to put that property, which is, again, one of the big issues there. If we haven't got enough money in the SMSF, or we're not going to go down that suit, we want to do everything in-house, then we have to look at potentially doing a JV. If the arrangement features the SMSF borrowing money, whether that borrowing fails to meet requirements to be exempted from the prohibition on borrowing on LRBA, so that's your replacement asset. Again, you can go down the track and buy a flat, do it up, use the money within the fund for the reno, and then you've obviously got the borrowing. That's not going to breach. But if I go down, I've got a house, demolish it, build 2 townhouses, and I've got an LRBA, then it's a breach because I've got a replacement asset. Whether the SMSF is contravening in-house asset rules by exceeding the level of in-house assets allowed. Again, if you're using a 1322C, you just got to be really careful, particularly property dev, because once you get into that business stage, then you blow the whole thing up. There are ways out of it, and look, I'm not a, I've used it purposefully in the past, but we just got to make sure your timing honestly has to be down to the day. You cannot, if you're going to do this, it needs to be planned with extreme precision, and making sure that you've got Gantt charts from here until when the final amount is sold. Pre-sales, everything has to be looked at exactly. And again, the other good thing about it is if it is going to be a business, you don't mind a bank coming and putting a charge on the underlying properties if they're in a 1322C. If they're in a suit, remember this is, you've got to make sure that no one holds more than 50%, then you do it right from the ground up, and that's excluded from the in-house assets test. Whether payments out of the SMSF under the arrangement are in fact payments of benefits contravening relevant payment standards. So that could be, for example, if we've got the builder or the developer and we engage them and pay over the odds in terms of their development, fees, or alternatively what we're paying them as a builder. That has a few issues. Section 109 of the SIS Act, a sole purpose test, and obviously a legal release. They might try and take you on as a illegal early release of superannuation, because that way they can jail. Where the SMSFs are maintained on an arm's length basis, and again, we talked about that 109 just then. A couple other ones, also got to be careful of income tax matters such as the NALI provisions, which I've talked about, the anti-avoidance, which always gets up, and obviously GST as well. So we can go through there. I don't want to go through the whole element, but this is what the Commission is looking at. Again, what should you do? So they're going to keep on monitoring. Just make sure you get good advice around that, and make sure that generally it's good legal advice, so you're protected by legal professional privilege. Now, it then goes into the appendix, which goes up to, you can see their record keep, all the issues that he talked about there. So I don't think I've gone through, like a lot of this is pretty basic stuff, in-house assets, ungeared related companies or trusts, which is those 1322Cs. As I said, I'm not a really big fan of them, but as I said, if you conduct a business, give a charge over an asset, then suddenly it becomes an in-house asset. So again, 27, if any of these events happen, the investment in the related company or unit trust will no longer meet the exception of being an in-house asset, with the result that all investments held by the SMSF in that related company or unit trust, including future investments in it, will be in-house assets. The asset can never be returned. And it goes through, if the shares or units cease to meet the in-house asset exemption, the fund will be required to dispose of the shares or units in excess of 5% within 12 months. Again, Tony and I have purposely done that in a couple of cases. But look, honestly, I could write a letter of advice. You get a lawyer to write a letter of advice, but you're not going to get better than that. Really, Commissioner's got it, is all over it. Plus, he also says, here, additionally, we have concerns that some of the lease arrangements being established or renewed not being done, so formal written process. So again, if you don't have that, then you're in strife. Have a look at the example. Look, I didn't highlight it because, I'm pretty well aware of what's going on. LRBAs, look, I've talked about that, but look, there's a lot of troubles there. One of the issues he does relate, though, is where there's a LRBA on, for example, a related party loan over, I have seen these over some units in a 1322C. So that's one way of doing it, getting borrowings into the process by the superannuation fund, getting the units in that 1322C, but using a related party loan. Look, I'm a bit problematic around that one. If you have to get a suit, is better practically. But obviously, if it's a 1322C, it sits outside the safe harbour. And so then you actually have to go and have a look at trying to find a commercial entity for it. Again, have a look through that. That's pretty basic stuff. Non-arm's length dealing and non-arm's length income. It goes through quite a bit sitting in there. And this is quite an interesting one. I just want to spend a couple of minutes on because I'm cognizant of the time. John and Vanessa are unrelated individuals who come together to enter into a property development venture. John is the sole member of the JV SMSF and Vanessa is the sole member of the V SMSF. John and Vanessa incorporated a company, JV company, to conduct the property development activities. JVS and each acquire 200,000. So that's not a bad one. So that's a superannuation unrelated investment company, which isn't a bad vehicle as well versus a trust. Now, JV company uses a $400,000 invested to acquire vacant land. It then borrows $4 million from an unrelated bank. Now, here's the first one is they've spent $400,000 on the property. The bank will not lend this amount without additional security, and John and Vanessa need to provide personal guarantees and insurance, taking on the full financial commercial risk of the development. So that's where you're going to get caught from that one. And I won't go any further, but the Commissioner basically says, look, the dividends coming out of there are going to be gnarly and taxed at 45%. So have a look at that. Joint venture, again, you know, it's an association of persons for particular trading, commercial, or other financial. So essentially it's a partnership, really, when we have a look at it. The Commissioner goes down there and has a look there. And in 75, it says, in a joint venture with a related party, SMSF trustees also need to ensure their stake in the joint venture does not amount to an investment in or a loan to a related party, is therefore an in-house asset. We expect the SMSF to hold a proprietary interest in the real properties being developed, which generally the ones I've seen in the past isn't the case. But that goes back to why I said I prefer to see the property actually sitting in the SMSF, but then that can blow us up in terms of giving a charge. Providing financial assistance, remember, we talked about record keeping, we've done that. And then also sole purpose test, we talked about that. Now notice, we really haven't talked much about the suit. Where we go there is there's another one that I'll send you a link to just briefly. This is a guideline from the Commissioner. So the following case studies can help you identify and avoid retirement planning schemes. So this is straight up out of the ATO website. SMSFs and property development. We just got to be careful about this one. So this is much the same as the case we just had a look at there. There wasn't that much sitting in the unit trust when we go through here, but there was huge borrowings being dumped into the unit trust. And of course, the Commissioner has a bit of a concern around that and puts down what his concern is. So we find there that this is what he's going to do in that case. We revoke the SMSF's compliance status and disqualify the trustees. So you've just got to be careful. So it's been pretty hardcore in this case study. I think it's a little bit over the top, but essentially, again, we're doing it's a huge development because we end up borrowing, you know, around about $8-9 million. So just be really careful. There's different ways of doing it, but again, just be careful of SMSFs and property development there, which I'll send you through that link. Just a couple other ones, and then I'll bounce out of here again as well. As I said, the know the law, which is pretty obvious. You've got section 6284, which is in-house assets, 67A, 109, which is your arm's length. 54C is you've got to be really careful about your underlying trust deed. You've got to scan through all of the trust deed. I can't believe after Marcellus saw some dimwit on SMSF advisors saying that we're going to go back and we're going to have to upgrade our deed to put conflicts of, you know, so that the trustees of fund can disregard conflicts of interest, which I've always put that in the deed. It's crazy that you can even don't have it, which means all of their deeds that you're using from them effectively defunct for any property development, because obviously there's going to be lots of conflicts coming around. The mere fact that you're a trustee and you're engaged in property development, or you're a director of the corporate trustee of a suit or a SUIC, which is a superannuation unrelated investment company, is by itself an issue. So you've got to make sure that 54C, you've got the right set of rules, otherwise you're going to be blown out of the water as well. And there's a lot of dangers around that one. Talked about non-arm's length, you know, great analysis from the Commissioner. And also make sure you have a look at those elements there. So the Corps Act, LRBA, investment strategy, investment property, they're all not financial products, so you don't have to worry about that. More importantly, if you're doing a suit, a capital raising, capital raising is a managed investment scheme, and generally you need a product disclosure statement. However, if you're a wholesale investor, which ASIC did some guidelines going back about 15 years ago that says if SMSF has more than $2.5 million, they're classified as a wholesale investor. Sophisticated investor, if you get an account certificate, sophisticated investor, then they're excluded from having to give them a PDS. And for anyone else, if there's 20 investors, no more than 2 million any 12-month period. So if that's all you're raising, then effectively you're going to be in a position of not having to give a product disclosure statement. But you can only use each of these, so they're all mutually exclusive. So you could be a sophisticated investor, but they won't be included part of the 20 investors. And of course, loan funds are excluded as well. But remember, we want to set it up, and then the second phase is getting the money in the door for the suit. So a simple case study, John's a property is SMSF worth 1.5 million, which needs developing. Architect's gone to work with a spend of $2 million to develop 4 townhouses worth $1.1 million, even on current valuations. John's a builder, has done developments through his development company before. There's no shortage of funds to build the development. So what I would do is, it's probably too small for a suit, although you do know I do like the suit. But, you know, if the guy's a builder, he's already got this, he's got his capital there, he's going to want to do it all himself. So I would probably go a JV, bearing in mind, of course, we'd have to make sure it meets the Commissioner's guidelines there. 1322C trust, forget about that. Direct, you know, you're not going to be able to do direct as well. So for me, the go-to would be a JV. But if this actually ended up being a $5 million spend to get like 10 townhouses, then we definitely go a suit and start to open it up. But my go-to is actually a suit from any perspective. Before I come back, I just want to take you out and just show you on the Lightyear Docs site where all these documents are. So if you want to do it yourself, alternatively, it's best to, as I said, you can come to Abbott-Family and have a chat with us. So for those of you who do it quite significantly, you might want to get a subscription with us. But essentially the areas that we're going down to here, I'll go through each of these. Obviously, estate planning is an issue once we've set it up, particularly if it's a suit, you know, who gets the units. If there's loans, we need to work out what's going to happen in terms of wills. Is it going to be is the loan going to be forgiven on death? And which should be the case too with related party loans. You've got to be very careful about what happens there. So our business and our commercial agreements. So buy-sells, which is like a unit holders. We've got commercial property leases. If you're looking at doing commercial property, we will be doing some resis later, but that's going well and truly down the track after you've already done the development, knowing that you've got the ability to do leases here as well. You've got loan agreements there if you want to lend into the superannuation fund. If you want to do an SMSF loan agreement, the superannuation fund can lend to a suit. Believe it or not, so you'd actually use this document here. As you can see, all our documents are only $99, but generally, you know, there's a subscription there for $5.95 for unlimited documents. So if you're going to go through and do a few of these in wills, etc., you're better off going down that track. Commercial property lease, SMSF loan agreement, which also comes with a mortgage as well. Personal guarantees, if you want to do that. Your business partnership, not a bad one for a JV. If you're dealing with a build or whatever, you must have a services agreement. Remember, the documentation is all important from the Commissioner. So put that in place. It's got to be whatever the market value is for that services agreement. Otherwise, it'll be treated as potentially, if it's under, it's going to be gnarly income. And if it's over, potentially it's going to be a illegal release of superannuation or breach of sole purpose test or 109. So that's some really good ones there. We also want to go back and have a look at our trusts. With our SMSFs, all I've got here, you'd upgrade to obviously, you'd upgrade to, so there's your investment strategies there, which are really crucial. Where's the variation? Okay, so you do a deed of variation, or you can do one to leading member variation. which is our bloodline. So I'd be building this from the ground up before I then put in place the suit. I am going to actually build a separate section of the site and just put, much the same way as we do our estate planning, just put all our property stuff in there as well, so you can see. With the trust, you've got if you actually, a client's gone in and bought a property, they don't know it's in the nominee name, but you want to put in your SMSF or a suit, use a declaration of trust. That's what I would be using there for that one. That's what it was built for. You've got to remember that 1322C related trust, you can use that. I'll come back on that one a little bit later on. The superannuation unrelated investment trust, that's basically sitting there. So I can buy that one. That's a special purpose unit trust, which goes down so far as to, in the event that inadvertently one party ends up going over 50% and it's going to be corrected, effectively that methodology of going over is held in a suspense account. So we've really thought a long way down the track around that 50-50 rule. But again, if you've got more parties, it's much better off. And we cover what happens with the units in the event of death. So that's my absolute go-to if it's a decent size investment. But we have done JVs of $100 million developments with an SMSF. So again, there's no hard and fast rule. It's a matter of looking at all the variations, having a look at the Commissioner's guidelines. As you can see, when we had a look at that 2020 here, there really wasn't that much around a suit in there, which is quite beneficial for us. So you can use your suit and have the declaration of trust. And then I was thinking, sorry, you guys made me forget. What was I going to say? I shouldn't say you made me forget. Oh, yeah. So the other one is the strategy automation. If you want to do a related party loan into 1322C trusts or a related party loan into a suit, which definitely has big legs on it compared to a 1322C, then you'd simply use this or related party shares meeting Ato guidelines. I'll just go in all your documents whenever you do one. They all end up in a vault. So you have client files in a vault. You can see here I've got the related party. You can see I've got a lot sitting in here. I've got the shares, there you go, the RPL for shares that meet the ATO guidelines. Remember, we're going to have to necessarily change this and find commercial if it's a suit because the 2016/5 only applies to listed investments. But you'll see here when we do this, everything's automated. You set it up, put the Abbott-Family tag on, which is a legal firm. You've got your superannuation fund. You put the name of that. Obviously, it's been set up beforehand. You've got the trustee minutes, which is authorising the trustee to acquire a single acquirable asset, which would be the units. And again, have a look at what the Commissioner says in 1322C. It's very instructive of what to do and what not to do. Then we've got the holding trust details. The minutes of the holding trust talking about acquiring the single acquirable asset, because the legal title has to be in there. The related party loan, which talks about the related party lender. The loan deed details. Again, we've got the typical standards there, which are straight out of the Commissioner's guideline. So I'd stick with that anyway. And then you've got the mortgage deed, which is required. So that basically does about 6 documents in one, but only takes you about 10 minutes to do. So again, that's prime vehicle again when we have a look at for this unit trust stuff as well. So when we have a look at that, we're sort of, I'm getting to the end there. Preferably is, as I said before, I would love to go and get involved in doing like a full day or at least a half day where we can start going through a lot more case studies from small renos to really big ones. David Schildkraut has sent in pre-99 unit trusts. If you've got those, absolutely, David. So we're really going back and winding back the years there. But if you've got one in existence, you just got to be careful about the top up of the capital. But again, there's no LVR rate. So if your super fund wants to do that, the super fund can actually lend to the pre-99 unit trust. And the pre-99 unit trust can then go out and borrow by itself, do its property development. There's a lot of stuff there. So if you don't pre-99 unit trust, if you've got those, absolutely make sure you come and see us because I've got some good hacks around that one. So look, using an SMSF, that's where the cash is. It makes good tax sense. Look, it's a brilliant strategy. It's if I took you back 10 years ago, it wasn't a go-to strategy for a lot of people because no one even thought about it. Accountants, planners, advisors about, well, why don't we use our SMSF? I do the reverse now. So if I've got property developer clients or anyone who comes to me, I always look at it, well, basically, what should we do? Can we use the SMSF in that? So if the first go-to point is the SMSF, and then we work through that, then the best thing is to discount it after that. And even if it's a property development, some of you got clients that halfway or a quarter of the way through or 2/3 of the way through their property development, they can't get funds or they're having problems, offloading it because of COVID. Again, you can come in and the SMSF can buy part of that development, if it is a true property development, because it'd be treated as business real property, and you'd end up with a JV around that. Or alternatively, you could put it in 1322C, or you could put it up in a suit. So there's a lot of advantages for there. In fact, when there's a downturn in the market, it's the best time to actually use that SMSF money because it really punches above its weight. And given the fact that obviously with FIRB and a lot of the issues, we're not seeing many overseas investors now. So we're really back at a really good playing field. As I showed you, all of the documents can be found on Lightyear, like a suit, which is a special purpose vehicle, unit trust for property development. Gosh, it's $99. You went into a legal firm, it's going to cost you a fortune. So you can put it all together yourself. But as I said before, look, we're here to help you at Abbott-Family. I've had 25 years. Tony's had the same sort of experience. We know things have to be done quickly. So we turn around stuff really quickly and can do all the documentation, everything for you, or just simply review what you've got there. Either way, it's good to give us a call or contact Tony at tannermorless@abbottmorley.com with anything you've got. So at least we can do like a bit of a scoping call, the first one, and then we can scope out where you want to fit in, and then work out what needs to be done from that one. So again, it's a good issue, but we want to make sure, obviously, the property development, as the Commissioner said, is on his radar, which is why he released those guidelines. So we've got to be really careful to play within those lanes, which we absolutely ensure that we do. Anyway, without any further questions, as I said before, this recording will be up and available later on this afternoon with the regulatory bulletin, which will be marked up. I'll send a link to, remember those case studies that the Commissioner talked about with some retirement income planning strategies you just got to be careful of. I'll also send a link, make sure you come along to next week's webinar, because if you're going down this track, it makes sense to actually then go to all the potential unit holders, do all their wills, their testamentary trusts, EPOAs, just to make sure everything's clean, particularly if they're SMSF investors. You don't want to find out one of your unit holders or your major unit holders is being quarantined or stuck overseas. There's no EPOA, so that you haven't got a quorum, you haven't got anyone to vote, and that can easily happen, I can tell you, if someone passes away. So you've got to make sure that if the underlying structures are keen, then on the top we can do that. And again, that's just part and parcel of Abbott-Family. But go and have a look at all that. And look, I wish you well. As I said, it's a great time personally. We are going to go through some very, very hard times, I think, over the next few years. But again, for the party, I used to work at Rothschild, and what did the original Rothschild say? The best time to buy is when there's blood in the streets. And look, it's a good time to go and buy half-developed sites if you've got a bit of an idea, or go and buying at fire sale prices some of those dev sites and starting again. But anyway, it's great, Abbott, and thanks for attending today, and look forward to catching up with you shortly.